Administrative Law. This is your podcast week number 12. If you have me for civil litigation, I've already explained that, we're at week number 12, and I don't know about you, but I'm tired. I'm losing my voice. A lot going on, advising and all that stuff, and then 4 more weeks. So keep up your energy. For this week, some of the documents that I provided to you, I'm always happy when our graduates are willing to put together some things to help you out, because we have graduates working in every area of the law, and we have a bunch of graduates working in work comp, and somebody offered to put together this description of a checklist of what they do so people that don't work in comp have a good idea. The description and the involvement, the type of work, things that they do locally, it's just valuable stuff for you. Now keep in mind that one of the points not fully discussed, in the comp world, you might be juggling all those tasks that are listed times 400 or so files. If you ever get a little worried about whether you're going to be able to handle that many files, we can have a little Dr. Phil session, but I'll tell you that you will be able to. I had the same concerns when I first started taking cases. It was, wow, how am I going to juggle all these? But you do, and hopefully your work worked into them slowly, and you get the idea, and you get experienced, and you get familiar with all the processes, and then eventually you just do, and you'll remember things about each file without having to open the file, and it's just the way it is, and you'll close a file and get a new one. So just know that. Now we're talking about comp. The hearing is a bit less formal than a traditional trial. The setting's more like an office or conference room than a courtroom. The arbitrators and where they hear cases is found on the IWCC website, and you should always check for who and where your case will appear, as these are jurisdictional issues no less important than in a civil case or the courthouse, and they change. And where an arbitrator you may think they're going to hear a case may also change, because they're going all over the place to hear their cases. And you'll see that if you go look at the site. So check the site. Remember, just as a court docket, the arbitrators have a calendar, typically 1 per week in different locations. So you have to know where your case is venued, where the arbitrator's hearing cases, and sometimes you end up tracking the arbitrator down and scheduling your case at one of the other sites. But the thing to keep in mind is that your case is assigned to one of these arbitrators, so you find their calendar and their location, and it's not exactly an intuitive search, but it's something that you become familiar with and you have to do. Just like you have to figure out how to get on a court's docket or court's calendar. In the work trial or work comp trial, the petitioner or injured worker presents his or her case, the employer presents their case, and then after all the evidence and testimony has been presented, both sides prepare proposed decisions. The petitioner and the respondent would both create, or the lawyers would create, and you would help them, propose decisions. And the arbitrator can choose one or the other or draft their own. Essentially, that's their closing argument, right? This is what we think you should do to decide this case. Very informal. Now, there may be witnesses at the trial, or at the work comp trial, just like a regular trial, but again, very informal. Now, during the trial, you will likely be preparing and rounding up witnesses, and afterwards you may be involved in getting the proposed decision together. Most of the paralegals, legal assistants who work for lawyers who do a lot of work comp would go to the calls with them, especially when they have trial, to help them, and especially if they have multiple trials, to keep things organized. Just like I think I mentioned in civil litigation that, I would prefer Dean Weghorst, when she was my paralegal, be at the courthouse during a trial. Didn't always work out because she had other work and another lawyer to work for. So, and if it wasn't absolutely necessary, wasn't going to be a 5 or 6 day or 2 week trial or something like that, maybe they don't need you, but it's always preferred. So be prepared to do that. And that means you get to go travel a little bit. If your client doesn't agree with the decision of the arbitrator, you can appeal to the commission. A 3-member panel of the commission will hear appeals in Chicago or Springfield. So you prepare and file briefs, and you get a short time to argue, and it flies. It's the appellate court. I've been to the appellate court, all levels. The only court level I wasn't able to go in front of was the United States Supreme Court. But we had a brief there that was filed and accepted, and they ruled on the brief, but we never got an argument. But I made an argument at every level of appellate court, state and federal, and it's always interesting, fast. You never know. They can start peppering you with questions right and left and out of the blue, and you got to know your record. Well, be that as it may, it's still pretty formal, okay? It's pretty formal. It's in a very formal, very nice, usually, courtroom. This, you might be at some folding tables with a bunch of other people in the room. Sometimes they're quiet, sometimes they're not. I remember making an argument because I handled all the appeals for comp cases in our office for a while, and I remember making my argument, and one of the arbitrators, or one of the commission members, I should say, just starts yelling, "Please shut up!" Think about throwing you off your game, man. That was horrible. But you prepare briefs, and you make an argument, and sometimes they ask you questions throughout your attempt to make your argument, and sometimes they don't. And often they don't even acknowledge you, so you don't know whether they're listening or not. They're hearing, 50 appeals that day. If you don't like their decision, you next appeal to the circuit court in the county in which the case would have been venued. The circuit court, if you remember from our early discussions of judicial review, is the first stop in the court system for judicial review. So the trial court, Peoria County, circuit court. The judge does not hear new evidence. They only hear arguments on the record, but that is more formal. It's very much like the appellate case. If you don't like what the circuit judge decides or one party doesn't, then you appeal next to the Illinois Appellate Court Workers' Compensation Division. And that commences as with any other appeal, and then if you don't like that, well, there may be an opportunity to get to the Supreme Court. There may not. In any of these settings, though, your role is the same. You assist with legal research, document preparation, and making sure things are filed in the proper place, format, and on time. Comp is faster than civil litigation cases. It's probably more interesting at times. It's less formal. It can be more hectic, I guess, depending on, some people would say the exact opposite, that civil cases are frustrating and not as much fun. But there's always some interesting issues, as you've seen and you'll see in the next few weeks about cases. And it is something that you're likely to find some job opportunities in. This is your Week 12 podcast. Next week, we move on to application for adjustment and 19B forms and an assignment related. Next week's week 13, 3 more weeks after next week. Keep your energy up, and if you need me, you know where to find me.